In this video, we're going to take a closer look at the standard for patent eligibility in order for one to obtain a United States patent. Patent eligibility refers to the threshold question, even assuming that an invention is new, non-obvious, and can be written and described in a way that satisfies the patent standards. Is this, generally speaking, the type of subject matter for which we're willing to award patent monopoly rights? Now, the Patent Act says that one's entitled to a patent if they invent or discover any new or useful machine, process, manufacture, or composition of matter, or any new and useful improvement thereof. This is obviously a very broad description of the various categories of patentable subject matter. The courts have gone and carved out certain exceptions to patent eligible subject matter. These include laws of nature, natural phenomenon, or abstract ideas. A very simple example is this. If you were the one to discover that force equals mass times acceleration, this would likely be a law of nature or a natural phenomena, and you could not get a patent on the broad concept of force equaling mass times acceleration. However, you probably could get a patent on a machine or apparatus that somehow took advantage of force equaling mass times acceleration. So the law of patent eligibility has changed a lot over time and will likely continue to evolve as technological innovation pushes the boundaries of what we think should be patentable. There are two areas of technology that the courts have recently looked at to address whether these technological fields comprise patent-eligible subject matter. These are, first, software and business methods, and second, DNA-related inventions. In the context of software and business methods, the Supreme Court has recently said that if you're trying to patent a process or a method of doing something, this either has to involve one of the other categories of patent-eligible subject matter, such as a machine or a composition of matter, or that process has to physically transform some matter into a different composition. Now, this is pretty complicated and hard to figure out, especially when you're talking about a software-enabled invention. But patent attorneys, generally speaking, can take your invention, if it involves technology, and describe it in a way that'll satisfy the current law. The Supreme Court has also just this year addressed genetic inventions and whether those comprise patent-eligible subject matter. In doing so, the court said that isolated DNA by itself is not patent-eligible, but synthetic versions of DNA that omit non-coding portions, commonly called cDNA, can comprise patent-eligible subject matter. So again, for most innovations that involve technology, there's probably a way that a trained patent attorney can describe that invention in words, in what we call the patent claims, so that you're describing it such that it's patent-eligible subject matter. Again, the law is probably going to continue to evolve over time as courts address new technological innovations and new issues involving existing technology. So this points to the importance of including a diverse array of claims in your patent, because perhaps one method of claiming your technology will be ruled not to cover patent-eligible subject matter, but then you have fallback strategies, other claims that perhaps will claim your technology in a way that covers patent-eligible subject matter. And this is a very general overview of the law of patent eligibility.